When we're working on our client's estate plan, the decision on how to title the client's vehicles can be tricky. There are three main concerns that we must balance. First, we want to reduce probate exposure. Second, we want to minimize the amount of transfer fees and taxes to the extent possible. And third, we want to maximize asset protection in the event you are in a car accident that causes injury or other damage. Unfortunately, these three concerns do not always align in the way that clients hope they would. That's why it is up to you to determine what is most important to you. Today, we are going to discuss the pros and cons of titling vehicles jointly. Okay, so the first thing to know is that just titling your vehicle as jointly does not keep your car out of probate. The car title must indicate that it is owned jointly with rights of survivorship. This is indicated with the abbreviation JTWROS beside the owner's name. The default of the DMV is that they assume you do not want joint with rights of survivorship, so you must ask for it. Because most people do not know that they must ask for this, their legal title effectively states that they each own one half of the vehicle. So today we are going to talk about the pros and cons of listing your vehicle as owned jointly with rights of survivorship. First, there could be risks if you get into a car accident in the future. I'll list two examples. First, if you cause a car accident and get sued by a third party that is injured, if you and your spouse both own the vehicle in the car accident, then your spouse could also be subject to the lawsuit. This could further put your assets at risk. Or let's change the scenario. Say you get into a car accident and your spouse is a passenger in the vehicle. If your spouse is injured, then they may be barred from filing a claim with the auto insurance company if they are listed as a joint owner of the vehicle. Based on these two examples provided to you today, if asset protection is important to you, we may recommend only listing the primary driver of your vehicle as owner on the vehicle's title. So that brings us back to whether you would like to keep the vehicle out of probate or not. Now, there is a streamlined process available to a surviving spouse called a spousal allowance. The spousal allowance allows a surviving spouse to claim up to the first $60,000 in probate assets of a deceased spouse's estate. However, there is one risk associated with this type of process, albeit a small risk. If a common accident arises where you and your spouse pass away in a car accident, then the car will have to go through probate before it is passed to your beneficiaries or children. Now, if the car is the only probate asset, there still will be a pretty straightforward probate process for your beneficiaries, although it may not be as straightforward as the spousal allowance process that I have mentioned. Another option is to title your vehicle into a revocable living trust. However, if you and your spouse set up a joint revocable living trust, then you may experience some asset protection risks similar to the examples I gave moments ago. However, there is another option. We offer our clients, as part of our funding package, 2 separate automobile trusts that would hold each of the spouse's vehicle. This is important because it allows the vehicles to be titled separately for asset protection purposes, and also allows you to bypass probate by having the trust own the vehicle. These automobile trusts are simplified trusts, meaning that upon your death, they pour the vehicles over to your main revocable living trust. Now, if you do decide to update your title at the DMV, please note that there will be some processing fees to pay, but these are usually around $52. However, Be aware that North Carolina has what's called a highway use tax. This type of tax is what you usually see when you purchase a vehicle, and it can add up to a couple $100s. North Carolina law does allow a few exemptions to the highway use tax. These exemptions include a transfer to remove a co-owner, to gift to a spouse or child, or to include the revocable living trust name, so long as the owner of the vehicle is the sole beneficiary under the trust. We've set up our automobile trust to meet each of these requirements. However, the DMV does not always properly exempt individuals from this tax. So if you see this tax listed on an invoice, usually abbreviated as HUT, do not proceed with paying this fee. Once you have paid the fee, the DMV will not initiate a refund. Now, I know that was a lot of information that we just covered. If you're a client of our firm, don't worry. When you pick up your funding toolkit, you will receive a frequently asked questions handout that will go over the information we discussed today. If you're not a client of our firm and your previous attorney did not go over some of these issues, perhaps it's time to give our office a call and get a second opinion.